All right, it is exactly 1 p.m. and we are going to start the notice public meeting for the Child Support Guidelines Committee for November 17th, 2017. And we will start with our first agenda item, which is the call to order and the roll call. And we'll start the roll call now. Kathleen Baker.
Present.
Karen Cliff.
Here.
Ellen Crecilius. Here. Senator Farley. Assemblyman Fumo. Judge Hoskin.
Here.
Nova Murray.
Present.
Assemblyman Pickard.
Here.
Judge Robb. Senator Roberson.
He's on his way, Madam Chair. He'll be here momentarily.
Okay, thank you. Joseph Sanford. Judge Shirley. Justice Stiglitz.
Here.
Kim Surratt, I'm present, and Don Throne.
Here.
All right, we have a quorum. And I may be wrong. Do I see Assemblyman Fumo there or no in Vegas?
It's Ryan Sunga.
Oh, it's Ryan, I see. Okay. It's hard when you can't quite see the faces. All right, thank you. All right, we're going to move on to public comment. The rules of public comment are that they will be limited to 3 minutes. I will time you, and I will ask you to cease your comments even if your thoughts are not finished, exactly at 3 minutes. And we will start with Las Vegas. Is anyone present in Las Vegas for public comment?
Yes, ma'am, there is.
Okay, thank you. And if you could please announce your name and spell your name just so we have it properly spelled with the way names are these days, that would help us. And you may begin your public comment.
Alexander Falcone, Alexander Falconi.
Okay, you may begin your public comment.
I'm the owner of Our Nevada Judges. I'm a court-appointed special advocate for abused and neglected children. I'm mainly providing public input based on my own personal experiences. I've litigated, self-represented 8 years. Most of this will not impact me because the court has terminated my ex's parental rights, but I believe my input might be useful. The first thing I wanted to discuss was item 6. I read a portion of Jane Venor's report. I didn't have a lot of time to read it all, but I agree strongly with her ideas on imputation of income. I think that, ironically, the statutory scheme and existing case law is already somewhat consistent with what she's recommending, but I think in practice, the district courts appear to routinely impute income, and I'm not surprised that the issues reached people's ears as to being a problem. In my personal case, my income was imputed for attending college, and ironically, I did graduate and it tripled my income, so it would have actually provided for more of a child support consideration based on that. But nonetheless, I wasn't willfully underemployed for the purposes of avoiding child support. I was willfully underemployed for the purposes of attending and graduating college. I also noticed that there was a case where somebody's income was imputed when he was working more than 40 hours a week. Basically, the court imputed his income up to getting overtime pay. So I think it would be useful for this committee to codify that to prevent that from happening again in the future. I looked at item 5, and I strongly agree with this idea of self-adjusting orders, because especially if you're a low-income person, when you're working in low-income jobs, a lot of time you get a schedule that changes every week, and there was times when this would have very much affected me in a positive way. And there are also people who get commission, and sometimes that commission will spike within a month or two but not be consistent through the remainder of the year. Attorneys are not always forthcoming in this and will sometimes I don't want to use the word coerce, but I'm going to move on to item 4. Stipulations. This would definitely, I think there should be a lot of attention on stipulations. I did stipulate to modifications of child support, but one of the things that I think would help is if this committee mandate the retroactive modification to the date of filing the motion. I think that in my case and other cases, sometimes people, if they feel they can save 2 or 3 months worth of child support, will deliberately have that go to court, and even though they lose at the hearing, they still pocket the money. I think that would also help with preserving judicial resources. I noticed that there was an item on discussing things in the future. I'm not sure if any of this will be useful or if it's even within the power of this committee, but one of the issues I looked at was child support orders when a person has fled to a foreign country and uses a foreign jurisdiction to frustrate that person's child custody rights. I think those parents should be protected. The other issue was execution on assets held by the Secretary of Treasury by unclaimed properties division. There are assets there, but this issue is complicated.
Okay, sir,
Somebody
that was 3
actually-
minutes.
Okay, thank you.
You're welcome. Thank you for your very thoughtful testimony today. Does anybody on the commission have any questions? You can remain there for just a second, just in case anybody has a question for you, sir. Would anybody like to ask him any questions or comment on his public comment? All right, seeing none. Sir, I do believe a lot of your comments today we will be addressing either on today's agenda or throughout the rest of the work of this commission. I appreciate you coming here today.
Okay, thanks for your attention.
Thank you. Is there anybody else in Las Vegas that would like to give public comment? Okay, come on up, sir. And if you could start with stating your name and spelling it, I don't count that against your time, but then I'll start the timer after that, sir.
Okay. My name is Michael McDonald, MICHAEL, MCDONALD. I work with various groups, Restoring Freedom, Veterans in Politics, Reforming Family Courts, the FCLU, the Family Civil Liberties Union. Been working on a lot of different been working on all the different avenues in regards to family law reform. I would like to bring up a few issues regarding the proposed amendment that you guys are putting in with Assembly Bill 278 and a few other items. As of right now, the current bills that are in place in regards to child support haven't been reviewed in years. It is still following the 1950s guidelines. They haven't been very well versed and changed in that amount of time. A lot of it in regards to Section 42 of 666 is all based on the child support enforcement. There's not the actual involvement of the parents. So what I would like to propose is that there'd be more parental involvement, and that there would be a commission that would look into how other countries and other states are doing child support. As of right now, in custody disputes, it's one of the first things that's used. It's in this adversarial process is that it pits parents to fight over their own children because of money. I was personally affected by it, but there's so many people that I've been in talks with that it's causing the deadbeat dad syndrome. A lot of the families or parents aren't able to pay the exorbitant child support rates, a percentage of your income. In other countries, I'd implore you guys to watch the documentary Divorce Corp. As in other countries, they set a flat rate based on what the national average is and lower it based on parental involvement. So it encourages parental involvement instead of the enforcement and alienation, where they take a person's license away. They put them in a debtor's prison that was eliminated in 1833. They take away passports. There's so many different issues that are affecting millions of parents that it causes them to go and quit their job or stop working or providing income or providing for their family, as they're not essentially stripped from their own children because of the child support. So I'd ask that you guys look into how other countries do it based on a flat rate. You guys accentuate parental involvement, lower the child support based off of that. As right now, there's millions of kids, 23 million, are being alienated from their own parents because of a system that accentuates a matching system under Title 4D, which I would really implore you guys to repeal that Section 42, 666, and 667, as it's causing such it's one of the root causes of so many social issues: anxiety, depression, mental illness, criminal history. drug use, all stems from not having parents involved in their lives. So this is affecting millions of parents. I was also affected when I was a child. I was alienated from my parents when I was 5. And a lot of it was due to money and other issues. And it's caused such an effect on my life and so many others that I've been in talks with. People are getting thrown in jail, and I've been doing a lot of court observing. How is that benefiting them to take away their license where they can't go provide an income for their family, or to get an income, or to go throw them in a debtor's prison? So please look into that. I'd also like to send an email to you guys if I have some extra reports on that, if that's okay.
You're welcome
And
to.
proposal issues.
Yes, if you look at our agendas, it has information on there on how to submit documents and information to the committee, which is a very efficient way of getting more information to us than you can get in 3 minutes, obviously. But you are invited to please do so for our next meeting that we'll have, and that way we have it as an agenda item, whatever you've submitted to us.
I'd love to. Is the email
The more
located on the documentation?
it's on the agenda. You can find the information on how to submit it. And the more timely you get that to us before a meeting, obviously, the easier it is, because we have to follow public meeting laws and get things on the agenda in a timely fashion. So the sooner the better. Thank you for your time, sir. Does anybody on the commission have any questions for Mr. McDonald before he leaves us? No, okay. Seeing none, thank you for your time, sir. Is there anybody else in Las Vegas that would like to
Thank you.
give any public comment? Okay, come on forward.
Good afternoon. I'm
Hello,
Shan
if you will,
Weinset.
if you'll state your name and spell it for us first, and then I'll start your time. And you have 3 minutes, sir. Thank you.
Thank you. Shan, S-H-A-N-N, Weinset, W-I-N-E. S-E-T-T. I'm a family lawyer in Southern Nevada. I have 3 suggestions for the commission, and I thank you for the opportunity to address the commission. One is I would like the commission to consider the family law section's arguments in the Diaz case, in the Supreme Court case number 70371. That's the docket number. Basically, the family law section suggested that when there's an emancipation, there's an automatic ending of that child support obligation. That's an issue that the Supreme Court has not yet addressed, and it would be good if this commission could clarify that issue. That's one. There's another issue with regard to the 10% penalty on child support arrearages. That was addressed in the Supreme Court case Vail, V-A-I-L-E, Supreme Court docket number 53798. In that, the Attorney General submitted an amicus brief in which it indicated that the statute, NRS, NRS 125B.195 is ambiguous, and the problem is the 10% penalty that creates a super interest rate on arrearages, which causes a person to go in arrearages and never to get out of it. And it doesn't. And the AG's office also argued that it doesn't really inspire timely payment of the arrears. So I'd ask the commission to consider the AG's argument set forth in that Vail decision. And finally, I don't know if it was within this commission's ability, but I would also ask the commission to consider some way to take the emphasis off the labels of joint versus primary physical custody in terms of establishing child support, because that seems to cause some unwanted litigation over custodial labels when it's only really about the amount of child support that's going to be paid, or the obligation. I don't know if that's within this commission's, because I know we're dealing with custody versus child support, but those, if it's within the commission's purview, I would ask the commission to consider that as well. And that's all I have for this afternoon. Thank you.
Thank you, Mr. Weinset. You're below 3 minutes, which for a lawyer is pretty impressive. We'll ask the commission if they have any comments. I'll comment on your 3 points, just to give you some information. We are considering self-adjusting orders today, which the theory behind that is to also discuss emancipation and how to deal with that within our statutes. As of one of our prior meetings, this commission had voted, and the motion passed unanimously to alleviate our penalties. The interest rate is not within our purview, but the penalty did fall within one of the statutes that the legislature gave us authority over. But we've already made that decision to do that for the exact reasons that you gave today. And number 3, in terms of getting away from a joint versus primary custody, that is the heart of our biggest discussion and what we're trying to figure out with this commission. And the hope is to go that direction if we can figure out a means of doing so. Does anybody else have any questions or comments for Mr. Weinstedt today?
I do. Do you have any ideas on how to decouple a timeshare custody label from calculating child support? What are your ideas on that?
The only ideas I would have is look to the west toward California and their DISO master system. It's my understanding that California has kind of created a situation where the child support is based more on the overall timeshare as opposed to an actual label. So it's more proportionate. I think that would be a direction to look. In regardless of California or any other state, I think the concept would be more aligned with the amount of time that the parents are spending with the children versus just a label, is this joint or not joint? Because that's what in litigation that we seem to always be fighting. Do we hit that 40% cusp? It means nothing except a label.
Any other comments or questions? Seeing none, thank you for your time today. We appreciate it.
Thank you very much.
Is there anybody else in Las Vegas that would like to come forward for public comment? Seeing none, we will move to the telephone. Is there anybody on the telephone that would like to give public comment?
Yes.
Okay, please announce your name and spell it for us.
Yes. Can you hear me?
We've got a lot of wind noise with your telephone connection, so if you can get somewhere where we can hear you better, that would be appreciated.
There we go. Is that better?
Yes, that is better. Okay, what's your name?
Thank you. My name is David Schoen, David Schoen.
Okay, David, you have 3 minutes to give your public comment.
Thank you. I'm an advanced certified paralegal in Southern Nevada. I hold advanced family law certifications through the National Association of Legal Assistants in child custody, support and visitation, and division of property and spousal support. This morning, I forwarded to Ms. Surratt a proposed child support calculation method. The proposed method starts by taking each of the parents' gross monthly incomes and combining them to create a combined GMI. Next, we look at the Western Region data table from the recent USDA report already reviewed by this committee. By removing the healthcare costs from the tables, because these are typically assessed outside of the child support calculation, adjusting the amounts for Nevada by comparing Nevada's cost of living to the average across the Western region, and adjusting the 2015 numbers for inflation, we ascertain the low, middle, and high income cost averages for raising a single child in a 2-child household. Those 3 income points are used to create a formula for each age group. A calculation is performed for each child based on their age and the parents' combined GMI, and adjustments are made based on the number of children in the family. The end result is the cost of raising a child or children for that family. That cost is first divided between the parents pro rata to their GMI. Then adjustments are made based on the parents' respective parenting times, similar to a sliding scale where the cost of child rearing shifts more to the non-custodial parent the less time they have. By doing it this way, as Mr. Weinstedt just said, we can avoid traditional labels such as joint and primary and focus more on parenting time. Second, parenting time adjustments are made individually for each child, thus solving the issue on how to assign child support with the split custody arrangement, as the Nevada Supreme Court now is dealing with in Miller versus Miller. Adjustments can be made based on the support of other children and if either parent is ordered to pay for the other parent's household expenses, since these costs are already factored into the child support data to avoid double dipping. The final 2 numbers for each parent are compared, deducting the smaller from the larger, with the parent who has the larger amount owing the difference. That support obligation is compared to the presumptive minimum, $100 per child, and the maximum of the 18, 25, 29% we're used to of the GMI, with the obligor paying no less than the minimum but no more than the maximum. All of these calculations and variables seem difficult, but they can be plugged into an easy-to-use Adobe PDF form, which only requires the parent's GMI, the number and ages of children, and whether either parent supports other children or pays household expenses for the other parent. I have already included these calculations in a sample child support worksheet, which was also forwarded to Ms. Surratt this morning. I ask that the committee review and consider my proposal or any part thereof when making its recommendation to the legislature. Thank you.
All right, thank you. Mr. Schoen did send me these documents this morning. Obviously, that is in too short of a timeline for me to be able to post them for the public and give notice on them. I asked him to give public comment today so that we could then forward those documents on to the committee for the next agenda. Mr. Schoen, my comment to you is that the amount of work that you put into this for this committee is, from what I have seen that this committee has not seen yet, is outstanding. You really, it's a yeoman's work, and I really appreciate it. It's nice to have the public step in and do such work. We'll get that out to the committee, and my goal would be to put you on a future agenda so that those documents can be reviewed in detail, and we can take a look at your methodology and what your thinking is behind the system that you've proposed.
Yes, absolutely. Thank you.
Okay. Does anybody on the commission have any questions for Mr. Schoen? Seeing none, is there anybody else on the phone that would like to give public comment at this time?
I would, please.
Okay. Please start by stating your name and spelling it for us, and then we will go from there.
Okay, my name is Melissa Porter, Melissa-Porter, and I'm from Reno. I'm a paralegal and have been in Northern Nevada for over 20 years. And my family personally has suffered as a result of a parent concealing and lying under oath on financial declarations about their income. And today what I'm requesting is that the concealing of income be taken seriously and that the district attorney require employers of both parties to complete the financial documentation to prevent the misrepresentation of income. Right now, they only require the quote unquote non-custodial parent, even in a joint custody 50-50 situation. And allowing no consequences of not being honest about incomes affect not only the parent but the children, and it needs to be taken seriously. In addition, the non-custodial parent is automatically labeled as a deadbeat, and I feel it's really detrimental to, of course, not only the children but the parents as well. And that's it. I thank you very much.
Okay, Ms. Porter, thank you for your testimony. I do believe you were the one that testified at our last meeting. Is that correct?
Yeah, that was me.
Okay. We haven't forgotten about you. I promise. What I can tell you is I'm going to give you one comment, which is we have to remember what the purview of this commission is, which is the calculations of child support. We don't have any authority over changing policies or procedures within the district attorney's offices. It's all about coming to a calculation of child support that is fair and equitable for the children of the state of Nevada. Within that parameter, we will do our best to address your needs if there is a possibility for us to do so. But we only have so much authority on this commission. We don't have carte blanche to change any statute that we want. We have been told by the legislature we have a select number of statutes that we're working within.
Okay, I appreciate that.
Okay. Is there anybody on the commission that would like to ask Ms. Porter any questions? Or any additional statements? Seeing none, thank you, Ms. Porter. Is there anybody else on the phone that would like to give public testimony? Hearing none, is there anybody in Carson City that would like to give public comment? Seeing none, we will move on and close that agenda item and move on to agenda item number 3. Before we make our way all the way through this agenda, we do have a long agenda today, but part of that is because at the last meeting we did make a determination we were going to add the rest of the items from Exhibit 44 of the guideline review, just in case we had the ability or chance to get to it. So I don't have an expectation we will necessarily do everything that's on this agenda, but some items may be tabled for future meetings. Item number 3 is approval of the meeting minutes from October 20th, 2017. Do we have a motion to approve those minutes or modify?
Move to approve.
Who made the motion? Sorry, I
Keith
can't see.
Pickard.
Oh,
That's okay.
all right. Thank you,
Move to
Assemblyman Pickard. And do we have a second?
Kathleen Baker, I'll second.
Judge House, sorry.
All right. Kathleen Baker seconds the motion. All in favor, say aye.
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 If opposed, say nay. Motion passes. All right, we'll move on to agenda item number 4, which is discussion and recommendations regarding stipulated modification of child support. We had a agenda item request for this item from Ms. Baker, and I'm going to put you on the spot to lead the discussion on this.
Kathleen Baker. I brought this up mostly because in the cases that I'm seeing, we often have people who come into court who wish to make an agreement that does not necessarily comply with statutory requirements. And I believe that it would be appropriate for this commission to consider a way for them to be able to do that. I think we clearly have to look at issues in terms of whether there are domestic violence concerns, whether or not the children's needs are going to be met with respect to any kind of deviation or an agreement that does not comply with the statutory requirements. But oftentimes that can be the case, and it meets the family's needs. So I'm bringing it up for that particular reason. I see in court hearings that oftentimes to accommodate that, there's sort of a wink and a nod to the deviation factors, and especially if we're going to be coming up with some potential formulas for how to calculate deviation factors, that's going to remove the leeway in that area. So I just think it's critical that people who come into court have the ability to make some kind of agreements as long as their children's needs are being met.
Any input from the committee on stipulated modification of child support?
This is Keith Pickard. My concern really stems from those situations where there's an unequal bargaining power in the dynamic between the litigants, and so sometimes we can end up with calculations that are truly inaccurate based on the income. And I know the Supreme Court has said that we have to make specific findings now as to what that gross monthly income is for each of the parties and move forward. So ultimately, I agree. In fact, one of the bills I brought this last session, and I intend to bring it back if I'm reelected, is to provide for summary proceedings when parties agree. So while I agree with the intent, I'm particularly mindful of times when that may not end up with an appropriate result.
This is Judge Hoskin. Just on that proposal, is it the suggestion that essentially you'd leave it to the court to make the determination as to whether we're meeting those needs, and that being put in the form of a deviation factor, or what is your thought?
This is Kathleen Baker. So it's interesting to me, I'm with the Washington County District Attorney, and so we often prepare stipulations for parties, and those stipulations do not always have gross monthly income of the parties. It doesn't always have that information in. I've yet to see one of the stipulations not be signed, but we also have people who come into court and they want to have the court approve the agreement that they're making. I think that's something we need to explore. I'm very conscious of power imbalances, and I don't want to see a parent who has a primary timeshare walking away without the ability to take care of their children. But there have also been times when the parent who has the primary time doesn't need the money and the other parent does, and they're saying, we don't want it. And I think that there has to be some ability for the parent to be able to do that and not be in violation of the statutory requirements.
Judge Hoskin again. I think I understood all of that from your initial, but as far as putting it in pigeonhole, for want of a better word, for how we're approaching this, we've had discussions in the past about deviation factors or perhaps taking a lot of that discretionary power away from the court. This feels like you're suggesting that we put the deviation or put the discretion back in the hands of the court. I just want to be able to wrap my head around the suggestion with regard to the stipulations. I don't know that I disagree with you on any of the suggestions you've made. I'm just trying to put it in a framework that we can work with, and wondered if you had an opinion on that.
I'm not certain that I would think of it as a deviation factor. This is Kathleen Baker again. I think it would be more about a finding that there is not a situation that's arisen where one parent is being pressured to accept less support than is needed, or that there is not that kind of power imbalance, rather than saying, because you're agreeing, we find the deviation, we're going to deviate from the standard. More about the findings that this is not, based on the testimony of the parties, that this is not an unfair agreement that they're reaching.
I think this Kim Surratt, I think this falls into every other category we have, which is figuring out what language to use. I see this often, but you see it in different formats. You see the duress part of it, and then you see the non-duress. I think when a person voluntarily determines that they do not need child support because they know the other party needs that money, they don't need it, they're coming to that agreement. I mean, who are we to stand in their way? But I would agree. I would stay away from deviation factors. Obviously, we know that's kind of the bad word when it comes to our federal requirements, is to have too many deviations, but rather a finding by the court that duress does not exist in that circumstance, that they were at least vetted in court for their understanding and know what they're doing when they stipulate and agree to it. Beyond that, I'm comfortable with it. Of course, drafting that can always be tricky on how to determine. But I do see people come in who say, he's threatened me that if I don't waive child support, he's going to do everything he can to take the kids away from me. We do hear those statements. We hear those comments all the time. And of course, they can't waive child support. So it's an easy answer as a lawyer right now to say, yeah, it's not even possible for you to waive child support. And I think it is a stopgap for that sometimes. But I don't know what the prevalence is of the duress element of that. And if it was screened through the court, through testimony in front of the judge, would that help alleviate that concern or not? Do we have anybody else on the committee or commission that has comments or statements regarding this issue?
Karen Cliff from the Clark County District Attorney's Office. I just want to say that we embrace Ms. Baker's perspective on parties agreeing and attempting a stipulation. In Clark County, that's the first thing we try to do, is get both parties to come in and stipulate to an order. We do make specific findings in Clark County with respect to income. If it's zero, we note on the order it's zero, and if there's income from either party, it's always noted. And that's to facilitate a modification down the road so that we can show a 20% change in income, so we can show a change of circumstance. So I do believe it's critical so that down the road, if we do want to modify the order, we absolutely can do so. Trying to find a balance between allowing the parties to stipulate without necessarily having specific findings, I think will be challenging. I can't say that we've ever denied a party the ability to come to an agreement, even if it does fall outside of the statutory scheme. We do that numerous ways. As Ms. Baker noted, perhaps it is a wink, wink, nod, nod. But I think we've always been able as an office to facilitate an agreement between the parties. But I'm just not sure of another way we can go about doing this. But I'm open to ideas.
Nova Murray, for the record. I'd like to continue the conversation in our next meeting and maybe go take a look at other states if they are facilitating that, and maybe think about how that fits into what we call a guideline, like how it will fit, kind of like Kim said, how do you keep that from being a deviation and what would that look like? So a lot of times I get good information from other states. So I would love to keep it on and let us go ponder the situation. Thank you.
Do we have a consensus on the commission to table this discussion for the next agenda and allow Ms. Murray to do the research for us, because she just volunteered to do that research to determine if there are other states that have similar language that we can look at and determine if we can avoid it being a deviation factor.
So moved.
I'll make the motion.
I think Judge Shirley had that motion first. Assemblyman Pickard, would you like to be the second?
No problem. I'll second it.
All right, second. All in favor, say aye.
Aye. Aye.
Opposed, say
Aye.
nay. Motion passes. All right. We'll go on to agenda item number 5, which is a discussion and recommendations regarding self-adjusting orders. And I believe this agenda item was requested by Ms. Cliff, if she would like to lead the discussion on this item.
I brought this up because it's been a discussion among several attorneys whether this is something the committee should address, can address. Depending on how this plays out, I'm not quite sure our office is in support of the self-adjusting orders. But again, I think we need to have some conversation about it because it does seem to float around the family law community quite a bit. But I'm going to defer. If this is just solely my agenda item, I'd be happy to take it off the agenda. But I'm open to discussion.
I would encourage we don't take it off the agenda, and I'll tell you, I think for the purposes of our commission members that maybe aren't practicing as much as we are in this area, one of the biggest issues, which was brought up during public comment, is regarding emancipation of minors. And I know this is an ongoing problem within the state of Nevada, and so I'd rather us have the discussion about children emancipating and the child support obligations continuing. And some of the discussion is part of that is poor order drafting on whether it's attorneys drafting it or whether it's coming out of the court system. But if not enough attention has been paid to the fact that you have 3 children on this child support order, you have a sum total, and you have children emancipating out at different ages, how does that order adjust? Obviously, you can draft the order where it adjusts within the order, and you could spell it out, and you can actually say how much it's going to drop down to once each child emancipates. So when the first child emancipates, you're down to 2 children. A lot of people in the public, their instinct is to take that total child support amount and divide it by 3 and take out 1/3 of it when you have 3 children. And we run into huge problems at that point because a lot of times they're underpaying as a result of doing that calculation. And subsequent motions for contempt and enforcement are had, and that party, even though everybody agreed at the time to do that, make that calculation, is now in trouble for arrears and interest and no longer penalties, hopefully, in the near future. But I do think it's a problem. I think it's something to be contemplated within what we're doing right now. I don't know if other methods of self-adjusting orders were contemplated when you wanted this on the agenda item. I know that language is within the incarceration language that California had. That is one of our agenda items. in terms of how it self-adjusts automatically when somebody's in prison. But those are the two circumstances I know about. Are there other self-adjusting times when a self-adjusting order may be needed or required? Anybody on the...
Karen Cliff from the Clark County District Attorney's Office. I am in agreement. Those are the two situations that I'm aware of.
Dawn Throne for the record. It seems to me, because I've litigated these issues, and this litigation years later is very difficult for the litigants, very difficult for the judges to go back and say, okay, what would their income? What if we front-loaded the litigation and said, okay, if we're in child support court, we'll set a status check. We know when the oldest is going to probably emancipate, subject to high school graduation. And the district court judges, if they're doing it privately, could set a status check hearing and say, okay, we think 2 years the oldest is going to emancipate. You need to come back so we can recalculate the child support. Otherwise, people don't know to come and ask. And then they come with thousands and thousands of dollars worth of arrears to fight over with. And different judges, each one of them, have handled that issue differently on the back end.
Judge Hoskin, my concern on this has to do with the information available at the time versus the time when it's supposed to be self-adjusting. I think you'd be hard-pressed to say, okay, child support is now $300 a month, and in 3 years, child support's going to be $200 a month if you don't know what everybody's income is going to be at that time. So while I'm not opposed to a self-adjusting order, it may become unwieldy based upon the amount of information that would be required in order to make it an appropriate order. And are we wasting time and energy trying to guess at what it is if we're still going to have an ability when that triggering event occurs to revisit it anyway? So to me, it would be a very cumbersome analysis to do on the front load side when we don't even know what the circumstances of the parties are going to be at the time that the triggering event occurs. Emancipation, you will know that's the time when we're going to go from this percentage to that percentage, but we don't know percentage of what at that point in time, and are we simply going to leave it to the parents to stipulate or agree at that point in time as to what the income is? So I think we're opening up a can of worms, and I'm not sure that we understand how many worms are in the can.
I would
Keith
agree.
Bicker,
I'm sorry, Keith. Go ahead.
It's all right. Thank you. I agree with that. I think, though, that there is a fairly straightforward approach that we can use, similar to how we often discuss adjustments for alimony, where if we were to have an annual exchange of information between the parties of income, maybe their tax returns, so that the parties themselves are aware of the changes that come up. And I don't know if we need to put this in the regs that we're trying to develop, but maybe we do, where we have a requirement to exchange information. That way the parties are always aware of any changes that come up. And then the information will be there at the time when we're dealing with the self-adjusting order. It would certainly help the DA's office if they're involved, because there's going to be this requirement that the information be exchanged so that the party seeking the change can come in and just demonstrate what that is. But at the end of the day, I think that these are procedural questions in terms of coming up with an answer. I like the idea of the self-adjusting orders, because I think that the litigants are going to spend a lot less money this way by just being willing to report the income and make those adjustments rather than go through a full-on adjustment action.
Kim Surratt, for the record. There's two different scenarios I want to come up with, which is, obviously when you've got two children and one's emancipating out and you're left with one child, yes, we have the calculation issue. We have a lot of these where it's one child turned of age, and that child support obligation continues on, and it's going to go to zero. That's the answer. Saying you don't know what the income is at the time of emancipation is really irrelevant in my view, because whatever child support was set at that time you can make a determination of how much of it is attributed to each child at that time. If a modification is needed because incomes have changed at the time of emancipation, then maybe we make that a qualifying event for coming in for a review. Because right now we have 20% change and we have every 3 years, but if we add emancipation as one of those factors for when they can come in and have it reviewed, then that takes care of that problem. Because if they don't ask for a review, then there's no need to know what the incomes are at that time, because nothing's changing in terms of what that original child support order was. So if all we're doing is putting some procedures in that say the court has to allot child support per child or make a determination at that time of how much it will adjust upon emancipation, or maybe the procedure is you have to come into court no matter what on an emancipation, and we include language that's a procedural rule that says they have to come in for that and make it a qualifying event in order to do so. But I don't
Madam
think it's
Chair?
an impossibility. Yes.
Sorry to interrupt. This is
okay.
Bridget Robb. I'm joining the meeting.
Thank you, Judge. And I think also on roll call, we didn't have Judge Shirley at that time, and he is here at this time, and Judge Robb's on the phone. Thank you. Do you have any input, Judge Robb?
I was just hearing what you had to say, and I think causing people to come in every time there's an emancipation may be too much, but I very much like your idea of making it a qualifying event.
Keith Pickard for the record. I agree. That makes sense with multiple children. But to your point, Madam Chair, in a one-child scenario, there's no need for a review. It drops to zero. So, and I think that's the easy scenario, the one-child situation. There's really no concern. Emancipation means it goes to zero. That should be automatic, and there's no real need to review it past that. So I think that the relevant scenario is one where there's more than one child. We have to make a self-adjusting order to account for the emancipation of one, but not all. And then I think that if the information is available to everyone involved, it becomes pretty much an academic exercise, something that can be done almost summarily. But at the end of the day, that's the direction I thought that we should go with it.
This is Kathleen Baker. Emancipation is a huge issue in Washoe County. And I would say that in terms of when there's just one child, there is a complicating factor, because if that child has turned 18 and is still in high school, then that child can be entitled to support until they graduate from high school. So not everybody understands that, and there's a problem with people understanding the law. A lot of people who are coming into our courts seem to think that if we're enforcing that we are automatically modifying their support when the oldest child turns 18, and that clearly isn't happening. Our court is trying to do some per-child calculations. For instance, I had a case the other day where at the time that the order was entered in 2009, the gross monthly income was $2,080. And so there was $603 for 3 children. The first child emancipated in June of 2015. The second child emancipated in October of 2016. And we had a hearing just recently and had to deal with this issue of legal obligation to support stopping at the age of 18. We have the per child, but for instance, in this case, we would have the oldest child at $83, the second child at $146, and the youngest child at $374. And that's fine unless it's the youngest child who passes away for some reason. And then we've got the oldest child at 83 and the second child at 146. So it has some kinks. We can certainly look at doing that, but there are some issues that have not been resolved. And it is a big thing. People just don't understand they need to come back to court to resolve it, and don't do it.
Karen Cliff from the Clark County District Attorney's Office. I want to say that I am in agreement with Judge Hoskins' comments earlier. I do also want to add that, of course, as we know, emancipation occurs at 19 or high school graduation, whichever occurs later. I do have a concern if the state system, earlier, I do have a concern about whether our state computer system is able to facilitate self-adjusting orders in terms of as each child emancipates, can our system, because as you know, right now we do have nomads. So I think a secondary part of this conversation needs to be something from the state to weigh in on our new computer system to see if we can handle something like this change. Thank you.
Nova Murray, for the record. The new system does not have that slated for something that can be done, but anything can be done at a cost.
Keith Pickard for the record. Ms. Murray, are you past the RFP point? Do you know what all the design parameters are on the system, or is that still an open question? Is this something you could add to it?
Nova Murray, for the record. The RFP is complete. The vendor is in the middle of contract negotiation. It still could be added at a cost.
Judge Hoskin, just trying to frame where we are. As far as my comments earlier, I'm certainly in agreement that emancipation should be a basis for the court to review a child support obligation. Thinking back on it, I've always considered it a basis for review, and thinking about the law, perhaps I shouldn't have been doing it that way. But it just didn't make any sense any other way. So if we're looking at having emancipation being one of the basis for the court to review a child support obligation, certainly I would be in favor of that, and I think that's probably an easy fix. My concerns with regard to my can of worms analogy had to do more with trying to determine the unknown. And certainly if parties, and especially tied in with the last item we just put in place, if parties want to stipulate to some change occurring with the option of coming into the court for review upon emancipation, I think that may put us to a point where we can probably agree that that's the way that we go. I think it's just when we try and legislate so many unknowns that we have, legislate's the wrong word, but I'm going to use it, so many unknowns, I think we have a problem. Don't know if that helps or hurts.
Kim Surratt, I think that it helps, because really part of what we're talking about is we can add in some provisions to what we are doing that require orders to contain certain language. And if we require the orders to contain notice language about emancipation, getting the information to the public is part of it. Do they always read it? No, I get that. And they may still be in the same problem, the same boat they were in, because they never read their order to start with. But, we also tell them that they can't take off out of the country, or it might be kidnapping. And we have other requirements of what we have to put into our orders. I think mandating the emancipation language, that it's a qualifying event to come in for a review and that you need to have your order adjusted is down and dirty, something simple we can do without getting too far into the weeds or opening that can of worms too big. Any other comments or statements? Okay, I'm going to make a suggestion that I hate to volunteer for something at the moment, but I'll volunteer to try to come up with some of that notice language if there's no objection to that, and perhaps try to propose it at our next, for our next meeting.
Nova Murray, for the record. We might want to look back at our authority on this issue and just make sure before you go through the trouble that it falls in our purview.
I'm comfortable that it does, because it's not modifying any other sections. It would just be added to the sections that we're working within. We don't have any requirement like this somewhere else that we're modifying. Like the interest was in a different statute, and so we couldn't dip into that statute. We don't have this type of language in another location that we're modifying. So I think it would just go within the calculations, within the guidelines as to how to deal with child support. What's mandated to be in those orders, I think, can be within that same statutory structure. If I'm wrong, any comments, any thoughts?
Dawn Throne, I think you're right, because the statute that says when child support obligation ends for a child is in one of those statutes that's repealed. So I think I would go farther and say we have to have some kind of clarity that says an obligation for a child ends at X, because that's not going to be there if we don't put it in the regs. The statute's going to go away, which does say that.
Any comments or opinion about me bringing language back for a future agenda on notice, just the notice part of this and what goes in the order?
Do we, just as Judge Hoskin, is this an action item that we need motion second?
I don't think so.
The chair can table it.
I think I'm
Okay.
tabling it and just saying I'm going to come back with more information. And if we're good
And we're
with
happy
that,
to
we
allow
can
you to
close
do
this
that.
agenda item.
Yeah, that's appropriate.
Okay. I'm taking notes. Hold on just a second. So that I remember to do the research. Okay. I'm going to close that agenda item and move on to agenda item number 6, which is really, we have 6A through I, if that's not overwhelming. So really, we're skipping to 6A as our next agenda item. Discussion and recommendations as to what formula to use for child support after elimination of the presumptive maximum amounts. We're doing this pursuant to items 2, 3, and 5 of Exhibit 44. We were to have sample language drafted today for us by Commission Member Judge Robb, who, based on when the minutes came out, did not have the minutes, and then looking at the economic data, the timing for her to complete this item and have it to us, she was not able to do so. Judge Robb, since you're on the phone, are we okay with tabling this to the next meeting, or do you need a couple of meetings in between?
You'll have it next meeting.
Next meeting, okay. So Ryan, do we need to actually make motions on tabling, or can we just state we're tabling it to the next?
No, actually, it's your agenda, and you can
It's
do
my
what
agenda.
you want with it.
I love
Yes,
that. I'm tabling it. Okay, we're going to move on. We have item number 6B. Discussion and recommendations as how to set a minimum order with a self-support reserve / low income adjustment pursuant to item number 7 of Exhibit 44. And this was tabled from prior meetings, and one of the things that we wanted to have a look at was the economic data that we asked our commission member, Ellen Casilius, to compile for us. Ellen, do you want to give a little summary of what you did provide for us for this meeting, and we'll go off of that as a starting point?
Sure. So there's a handout with some tables on it I think everybody received. And the first page has 3 tables that I pulled some summary information out of the USDA report, the most recent USDA report on the expenditures on children by families. So the table that I labeled Table 1 shows for the United States in general, breaks it up into 3 different income ranges. Basically, they had a sample of families in their data, and they divided it into thirds. So the dollar amount of less than $59,200 is not, a certain federal poverty level cutoff or anything like that. It's just a third of their sample. So it shows the costs for children of different ages and the average expenditures of families. That's just the data I pulled from the USDA study. The shaded rows on there, I just computed the average for all ages and then the average percent of the average income. So you can see for the U.S., like for the lower income range, they're spending about 27% of their income on the children or the child. The middle income range about 16%, and then the higher income range about 11%. The second table there is the similar data, but this is for the West. They're labeling it Urban West, and the West region includes Alaska, Arizona, California, Colorado, Hawaii, Idaho, Montana, Nevada, New Mexico, Oregon, Utah, Washington, and Wyoming. So it's pretty big. They don't break it out specifically for Nevada or a smaller group. It includes a larger group of states, but it's probably more relevant to us than the U.S. as a whole. And I also added Table 3, which was specific for rural areas, because you can see that in the rural areas, they tend to be spending a smaller percent of their income on the child. So that's the first table. And then the other things I had provided, there was a question about how Wisconsin was calculating the information in the table we had discussed last time. So I have the table here reproduced, but also added some comments on the bottom about the calculations, which I can walk through if people need me to. And then what I did is I took the Wisconsin table and plugged in Nevada's rates on the table labeled Table 5, just as a quick comparison to see, well, what would happen if we used Wisconsin's methodology with the Nevada rates. So I'd be happy to answer any questions if anyone wants to dig into a specific area.
Keith Pickard for the record. My question is only, do you know whether or not the self-support reserve was baked into these numbers, or is that a separate consideration?
Well, in the information I was provided, they don't specifically say a self-support reserve. But if you look at the table labeled Table 4, that first row, the lowest income level, is the equivalent of 75% of the federal poverty level. And what they do is they compute how much the person would have to pay using the 17% rate that Wisconsin uses, and then take a third or 2/3 of that. So for that lowest income range, they're just charging 2/3 of what would have been the calculated amount. Does that make sense?
That does. I'll just state why I'm concerned about this. What I don't want to do, as we're discussing the self-support reserve, is make public this target. If you make this much or less, you don't have to pay child support, because that's going to create an incentive not to earn above that number. So if we can, I would like to make sure that when we're considering the self-support reserve, we're baking that into the table, assuming we're going with a table such as this. And I'm hoping we do. But I don't want to make the self-support reserve something that stands independent, because I think that just creates a perverse incentive. That's my personal opinion, but that's where that question was coming from.
And my understanding on this is that it's income up to the $754. They would be paying the 85. So I think there's what it looks like to me is that their minimum payment is that $85.
Judge Hoskin, can I ask a question on the first three tables? If I'm understanding it correctly, and that's what the question that I'm asking, is the expenditures on a child. So we're only looking at one child with these percentage numbers, and is there any information with regard to the support of more than one child and how that deviates from these percentage numbers that you have on the first three tables?
So the way they calculate the numbers that are in these tables is it's the estimate based on the younger child in a family with 2 children. And so they say the way you would want to adjust the numbers here on the page is if it was just a single child, you would multiply the numbers by 1.27. If there's more than, or the second child would just be, or this is the younger child in a 2-child household. And then if there were 3 or more children, you would multiply the number by 0.76. So they do provide basically a formula to adjust these numbers based on how many children there are in the household.
Is there, yeah, I don't know if there's confusion or just silence at the moment. Do we have any input on which one it is that we're hearing?
Can
Karen Cliff, Clark County District Attorney's Office, and I just want to say first, thank you so much for preparing this information for us. It's very, very helpful, and I appreciate the time that was taken to put this into Nevada rates. It's very helpful to see the difference between Wisconsin and how this would translate for Nevada. Just for clarification purposes, so are we sort of looking at a gross monthly income of $1,508 or higher? We would then be using the 18%. Looks like that model for one child. I see the 18, 25, 29, 31 sort of remaining. I know that was sort of up for discussion, but I do very much like this chart. Thank you.
Yes, my understanding is that anything above the 1508 would be at that designated rate, the 17% for Wisconsin or the 18% for Nevada.
If I understand correctly, Dawn Throne, how this is working in Wisconsin is that this chart is changing every year based on the federal data, correct?
Yes, that's correct. Each year at the end of January, the new federal poverty level data comes out, and they use those numbers to recalculate the chart.
Correct. So then, and they're using 150% of that as the top number, then they move into the regular percentage, correct?
Yes, that's correct.
So, quick question. I know it's monthly income up to the 754, but that's at 11%. So if we have income of only $200 a month, are we taking 11.88%, or are we doing the $90? We think we're doing the $90 as the way this is set up, the way Wisconsin does it right now.
That's correct. Based on my understanding of the table that they provided to me, if you're less than the lowest rate, the lowest income there, the 754, you would be paying the $86 a month.
Nova Murray, for the record, I thought that in the language, they built something else in outside of this table that said something contrary to that. I don't completely remember, but I kind of remember.
I think I remember that too. I think it was, for some reason, $50 minimum was hanging in my head, and I have no clue why. Yeah.
The $50, as I recall, Madam Chair, this is Judge Robb, came from the chart that we had that was a survey of other states. There was certainly an indication that most states have a number around $50 as their lowest amount of child support.
I believe you're right, Judge. We're digging through some documents really quick. I mean, either way, we're looking at numbers that are much more reasonable than what we have in Nevada, because if you go off of our $100 minimum per month per child, automatically that first number is $100. For the second child, it's $200. And, looking at the Nevada rates, it's very different from the $90. It goes $90, $124, $144, $154, $164. If we were doing $100 minimum per month per child, we're exceeding that extremely fast, obviously. If we do the math calculation of 18% of just the 754, child support comes out to $135 versus the $90. Just looking at Nevada's, just purely using what we have right now. And our first maximum caps stop at $4,235 of income, with a max amount of $696 in child support. So obviously, these numbers are doing a much better job of really looking at poverty level and adjusting for it at very different amounts than what we have in our system right now. I like it. I do have the same concern that you have, Assemblyman Pickard, about people utilizing knowing where they need to be on income levels. But when we're talking about $754 a month, we're talking low amounts to start with. They're either low or they're not, in my opinion, once we're in that dollar range. I mean, that's extremely low. Poverty is the $12,000 a year, $12,060 a year, correct, Ellen? And that comes out to $1,005 a month. So you're at poverty level when you hit $1,000 a month. So if you're below that, you're below that. I don't know if it makes a difference that $754 amount's there or not.
Keith Pickard for the record. I agree, and I guess my comment was intended only to make sure that we've not yet adopted the table. And so in the absence of a table that allows us to deal with the low-income obligors, I think it makes sense to simply say, I want to avoid setting a target at which people don't want to earn more. But if we have this, if we adopt a table such as this for low-income obligors, I think that resolves the issue.
Judge Hoskin, answering your question several questions ago about silence versus confusion, I'm gonna go with confusion. I'm still not sure, and of course I went to law school, which means I couldn't do math, or I'd have been a doctor. But I'm looking at the first page, tables 1, 2, and 3, and it's indicating that the cost expenditures for a child are 27% United States and 29% in urban West, and we're talking about 11% on that low end range. So are we ignoring page 1, or is page 1 something that we're looking to consider? Where are we on that process? Maybe I'm not reviewing the information correctly, and I'm certainly open to that.
Well, table 1, if you look at it, we're looking at incomes starting at that low income is at $59,000. We're not talking about the income levels of people in the poverty level of $12,000 a year. So
no, yes, we are. Yeah, that's before tax income is anything less than 59.2. So we're going all the way down.
Anything
the average
less,
is
right?
36.3.
But if you're making
Yes.
$12,000 a year and your average for a child is $9,705.
Well, then let's take the other end. You're making $1,500 a month. You're at 18% or 17% in Wisconsin and 18% in Nevada versus 29% as the actual cost. So I guess my question is either 1, am I not reviewing that, am I not interpreting that correctly, or 2, are we not going to consider the cost for raising a child as part of the calculations?
Do what, Judge Shirley? I'm going to have you talk out loud.
Well, I don't think you're ever going to make the cost of raising a child at the lower income thresholds. So I think what you're trying to do is try to figure out what the balance is, what kind of a percentage you can come up with that's fair and appropriate as you start hitting the upper income levels. But there's no way $1,000 a month won't pay for a child.
Nova Murray, for the record, I would also add that public assistance is kicking in those lower ranges that we're not counting. So we don't look at the value of their public assistance in these calculations. You assume it's baked in somewhere when we reduce it. And the children that are in our programs don't come anywhere near some of these dollar figures. So I think you're just looking at what the nation does on average when we get in the higher income ranges.
Right, for each income range that's listed here, they also list the average income in that range, and I used that average to compute the percent. So in table 1, for the lowest income category, the average there was $36,300. So that's what I used to compute the average percent of income.
Don Throne, but we're missing something. These tables are for married couple families, not single parent homes. So in an intact family, this is how much that family is spending on average for them. Now we're splitting this between 2 homes when we're setting child support order.
I guess, Judge Hoskin, I want to make sure that we're being intellectually honest when we're doing this analysis and not just simply looking at, okay, that seems like a reasonable percentage. I think I requested information on the first page, tables 1, 2, and 3, so that we have a better understanding of what we were doing. Once we get to the middle and high ranges, I'm fine. I think we're okay from a percentage standpoint. But I just want us to be honest in the fact that, and I don't disagree with Judge Shirley, I think he's absolutely right. I don't know that we're ever going to be able to get to the point when we have a family that's not intact having the same expenditures as one that is. That's the nature of what we do in family court every day. But I want to make sure that we're considering those costs as part and parcel of whatever we end up coming up with.
Kim Surratt, Ellen, do they have similar data for that isn't for intact married couple families?
They do have a table overall for the United States for a single-parent family. And what their analysis said, if you read the report, I did provide the link on the bottom there if anybody's interested in looking at their original report. They said that really the results for a single-parent family, the expenditures are very similar in dollar amount to the married couple families, but the difference we see is that more of the single-parent families are in the lowest income range.
Karen Cliff, Clark County District Attorney's Office. I just wanted to clarify, it does state married couple families, but it also does state expenditures on a child. So we are presuming an average gross monthly income of average yearly income of $9,705. So I'm looking, if that's correct, are we talking about a gross monthly income of about $808? So just looking on our chart, that's about 11.63%. versus the 27%. So I'm not sure if the married or single chart would look different because they're saying, I believe, household income, $9,705, but expenditures on a child, 27%.
Let me jump in. So the three columns there are showing the before tax income ranges. The numbers in the rows labeled like 0 to 2, 3 to 5, the dollar numbers there are the average expenditures on a child in that age range. So if we're looking at table 1, where you see 9,690, that is saying for a child age 0 to 2 in a family with before tax income less than $59,200. That 9,690 is the average spending on one child. Does that help clarify?
Yes, thank you.
I am going to propose that we table this to the next agenda also for all of us to digest these numbers because we haven't had them in hand very long. In addition, I would like everybody to get in hand the documents that David Sloan did for us and commented on during public comment. That has some very interesting analysis of this exact same data, and let us digest this some more. I know we just keep tabling this item, but until we really have a grip on these numbers and the poverty data and the average estimated expenditures on a child, it's really hard for us to have a good conversation. But since Ellen did the numbers, has them in front of us, now's the opportunity before I close the agenda item to ask her questions and really dig into it so that you can go back and really understand it. So if there's anything else you don't understand about what's in front of you, let's ask it now.
Karen Cliff from the Clark County.
Mm-hmm. Go ahead, Ms. Cliff.
Karen Cliff from the Clark County District Attorney's Office. In looking at the chart that was developed for the Nevada rates, prior to the 18% formula, the 17.78, we're looking at a gross monthly income of $1,481. We take that over 12 months, we're looking at a yearly income of $17,772. Would it be possible to get a chart regarding income and expenditures on a child for individuals in that income range? Because the current chart, while it's amazing, and I really do appreciate it, we're looking at income that is in the range of about $59,000. Is it possible that families in a lower income bracket, such as what we're looking at, up to 1772, perhaps spend differently on a child? If it's possible to get that information? Thanks.
The report from the USDA only provides these income ranges. It doesn't break it down into different lower income ranges.
Nova Murray, for the record, I also think that you're bringing in a piece of the puzzle that is public assistance. Our public assistance process, we don't count it as income. So anybody under 200% of poverty is going to qualify for food stamps, Medicaid, and so their medical expenses are pushed in there. Some of their food is in there. Housing also covers the family. So what a family would spend out of pocket versus what the state might pay is probably a huge ball of worms. Ball of wax? Can of worms?
Let me just jump in real quick. To mention the different areas of spending that's included in this total expense, they break it down in the report by housing, food, transportation, clothing, health care, child care and education, and then miscellaneous. So for each of these different income ranges and different regions, we do have the data broken down into those different components. So you can see what's the average spending on health care or average spending on housing and things like that. I only included the total in what I provided to you.
Judge Hoskin, a question for Ms. Murray. I think the gap in at least my logic may be public assistance. Is there a way to get some information and some data with regard to how much public assistance and to what income range so that we can take that into consideration? Because like I said, the second and third tier I think is pretty much in line with what we're talking about. In fact, maybe a little less. The first tier is my concern, and public assistance may bridge that gap from a logical standpoint. So can we get that information?
Nova Murray, for the record, I can get some basic information and maybe mill it over with Ellen to see how to best give the information to the group. We are working right now on a project to kind of give you exactly what you're talking about, but it won't be ready in time for this committee. But I can definitely get something and see if we can kind of show some of the basics. The other thing that I will do is contact Wisconsin and find out exactly how much or how it works with the self-support reserve in those numbers. We can clearly see it's in there, but finding out exactly what that looks like and how to unbake it out and show it, that might be helpful too, because that might be the piece we can compare to some of this. Not only are these families you're giving the money to probably on assistance, the money you're taking from people, both sides of the house are on assistance in a lot of our cases.
Don Throne, in the case where the payor is on public assistance, though, they're not paying child support, right?
Nova Murray, for the record, no, that's not true. Only if their public assistance includes temporary aid to needy families, which is the TANF program. If they are in other forms of public assistance like SNAP, child care, Medicaid, those families are still in an income range to provide child support.
Any additional economic questions regarding the status so that we can get into your hands what you need so that next time we have this on the agenda we can better analyze what we're doing? Seeing none, then I'm going to go ahead and close this agenda item and table it for our next meeting with the caveat that Ms. Murray has volunteered to try to get us some of those public assistance numbers and contact Wisconsin to discuss with them how they calculate that in or how it's brought into their numbers. And was there anything else that was required of you, Ellen? I don't think so. Okay. Yeah, I think I got that summarized properly. I think this is probably one of the most important things we can do to get this part right, because it's where we're really falling down on our calculations and supporting Nevada right now. So we'll move on to agenda. Yes, go ahead.
Sorry, Karen Cliff from the Clark County District Attorney's Office. I just, with respect to Wisconsin and the deviation downwards possibly for, as you indicated earlier, a gross monthly income, for example, in the range of about $200. I think it's similar to Nevada in terms of the judge being able to make those findings on the record and reducing the support below the minimum. If I can locate the statute, I'm more than happy to assist Ms. Murray and provide that to the committee prior to the next meeting.
Great. I would appreciate that. I think that would be helpful for everybody. All right, great. Let's move on to agenda item number 6C, discussion and recommendations as to how to address the treatment of incarcerated parents or parent recently released from prison. This is pursuant to item number 8 of Exhibit 44. I provided sample language. Full disclosure, I had a massive family emergency this week, so I literally took the California stuff, took out what we agreed in the last meeting to take out, and just dumped it on you. So it doesn't have the fine-tuned Kim reading it perspective, but you do have it in hand. I don't know whether you've had sufficient time as a commission to really look at that language. If not, then my suggestion would be to table it till the next agenda so that you can read it, but at least it's in your hands right now, unless there's discussion that anybody wants to have on it at the very moment. Everybody's reading it. So I will take that as, as a clear indication that we are going to table this, but you have the information in hand. What I would suggest is for the next agenda, if you can edit this or take a good look at it right away, we will get the document also distributed with your edits in time for the next meeting so that your edits can be looked at in detail and discussed. So that is everybody's duty and obligation as a job coming out of this meeting. And the sooner you get that to us, I know that's hard to say, but the better. And at a minimum, we have to post this will be on the agenda, but we have to post the exhibits within 2 days? 2 days? Staff?
It's 3, Madam Chair.
3, okay, within 3 days. So by minimum of 4 days, it'd be lovely to have it in hand. If you can bring it even sooner, that gives the commission time to read the edits that each of you are proposing so we can wrap our heads around maybe finalizing this part of an agenda item at our next meeting. Okay, I'm going to close that agenda item, table it for next time. Move on to 6D, discussion and recommendations as to how to limit income imputation beyond a parent's earning potential. This is pursuant to item number 9 of Exhibit 44. This is a fresh topic for us that we have not had on the agenda before. Item number 9 of Exhibit 44 specifically states that the recommendation when the guideline review was done on the state of Nevada that we limit income imputation beyond a parent's earning potential. Why? There is a national concern and at the federal OCSE level about the imputation of income beyond what a low-income disadvantaged parent can reasonably earn. For example, imputation at full-time minimum wage when the non-residential parent is disabled and cannot work full-time. Pending federal regulation encourages the use of actual income and to limit income imputation. This review was done before the actual federal regulations did come down, and federal regulations did come down, and they did have that encouragement and recommendation. The statement on how to do this from the guideline review is to review the best provisions of other states, including those newly adopted ones in response to federal concern and pending rule changes, and adapt, if appropriate, for Nevada. I open this up for discussion amongst the commission. Anybody like to start the discussion? Come on. It's a fresh topic, so now we have nothing to go off of.
Judge Hoskin, why do I feel the need to argue everything? I'm not quite sure. I'm a big fan of imputing income, and mainly because of what I do on a regular basis and the concerns that I have over litigants that...
Judge, hold on just a moment. For those of you that are on the phone, we can hear all the noise in the location that you're in. So if you could mute your phone so that we're not listening to the same thing you are. Thank you. Go ahead, Judge.
Yeah, the concern I have is that there are litigants on several occasions that will be earning less than they're capable of earning in an effort to reduce their child support obligation. And we have that ability in the law now to make those kinds of determinations. I would be reluctant to take a lot of that away. I understand that we'd prefer not to impute income, but there also has to be a mechanism to deal with those issues where we've got people being less than honest with their ability to earn an income. So that would be my take on this one.
This is Dawn Throne. One thing I find useful in my private practice and looking at how do I argue to a judge where to impute income for a specific fact scenario is to ask the parties to provide their Social Security statements, which show what their historic earnings are. Then you could say, don't set it higher than the highest earning they've ever earned under Social Security, something to have a benchmark so that everybody knows they're not intentionally underemployed, or if they are intentionally employed, we're not setting that income higher than what we know they're capable of earning.
Kim Surratt, Judge Hoskin, when we have a reasonable judge such as yourself, that makes sense. But then we have, such as the public comment we had today, which is I was going to college so I could better myself and income's being imputed to me because I'm trying to get an education. And the horror stories come out all over the state. And these are the things that we hear people just ranting and extremely angry over because there's no consistency. So, as in the approach with everything else we've got here, the question is, can there be some consistent language on when and how to impute income that will deter from those problem cases and those scenarios where people are just furious? I do see judges get angry and literally hate the litigant that's in front of them and impute out of anger versus reality. And what they actually can and are able to earn. And the pure fact that somebody earned an extreme amount of money before doesn't mean they still can. The other time when I saw this be a huge problem in the state of Nevada is when we had our housing drop and the market fell out. And in 2009 and onward, we started seeing people who had very healthy incomes that suddenly couldn't get a job to save their lives. And yes, they had prior high incomes, but they were now working a different job. As a family law attorney, I also see people who go, you know what, I could make that money as a married couple because we shared in the raising of our children in a way where it was feasible for me. But now that we are divorced, I would like to see my children more often, and that job is absolute hell. And if I go to it and I make that much money, it means I don't get to spend any time with my children. And we're going to impute that income to that person because they were making that before, and now they want to get a more reasonable job and work a more reasonable number of hours. This is where the problems come from. The disability example that's in the guideline review, I would hope is not common, but we may need comment on that, whether or not it is common amongst our judges to do such a thing, that somebody's actually disabled and unable to work and they're still imputing that income to them. That's ridiculous if it is the case. I don't know. I haven't seen a lot of that. I've seen it in the other scenarios that I was just mentioning as a private attorney. Back to what we have to do, though, or what we're required to do, the federal language that came to us from the mandates was very much about basing everything on actual real numbers and not just picking a number out of the air and saying we're going to impute this to you. The federal regulation does state that if imputation of income is authorized, that we are to take into consideration the specific circumstances of the non-custodial parent, and at the state's discretion, the custodial parent, which is something we've still got up in the air, to the extent known, including such factors as the non-custodial parent's assets, residence, employment, and earnings history, job skills, educational attainment, literacy, age, health, criminal record, and other employment barriers, and record of seeking employment, as well as the local job market, and the availability of employers willing to hire the non-custodial parent, prevailing earnings level in the local community, and other relevant background factors in the case. If we could pull all that off in one case, it would be a beautiful thing, but I know it's not necessarily realistic. But I wanted to throw it out there what the language is from the guidelines that, from the Code of Federal Regulations that is put in front of us for discussing this topic.
And Judge Hoskin, I have no problem with that language. Codify it.
How easy. Oh. Does anybody else have any comments or input? Is it as simple as codifying it?
Dawn Throne, how do we have data now on how other states have addressed this issue with the final regulation?
We are, as I understand the law, in order to impute income, there has to be a showing, number one, that somebody's willfully underemployed, and that they are doing so to avoid child support. Why would we want to change that portion? I can understand if there's facts and circumstances, they lost their job, that type of stuff, but that doesn't bring them in the willful underemployment provisions. And I understand judges get mad and all that kind of stuff, but I think the law is pretty clear, and the Supreme Court has some pretty good case law on how you have to prove that if you're the opponent.
Keith Pickard for the record. Judge Hoskin and I are trying to remember the name of the case that came out fairly recently from the Supreme Court that said if there is a finding that someone is willfully underemployed, then we presume that it is for the purpose of avoiding child support, and that's a rebuttable presumption. So I think that is the floor that we're starting from. At the end of the day, though, I think that codification of that language, particularly if that's been included in the newer part of the CFR, I suspect no other state has done anything with respect to that because it's too new. But we have an opportunity. I think that that will give us better direction, or give the courts better direction how to deal with the imputation of income, or at least determining whether or not the person's willfully underemployed. And I think it will give further clarification to what the Supreme Court was trying to do in that case. And if anybody can remember the name of the case, please help us out.
Is Mr. Weinset still in that room? He might know the name of it.
No, he left.
Ah, see, too easy. All right. I'd make a motion to codify the language within the CFR number 302.56 A, Roman numeral lowercase 3, C3, which is the one I just read. The imputation of income is authorized. If it's authorized, that you have to take into consideration all those circumstances. And start with that, and then maybe table additional language changes when we can bring back that case and take a good look at it and see if we need to codify additional language. How does that motion sit with everybody?
Madam Chair, I think I would like to, Keith Pickard for the record, I would like to review that language again before we adopt it as something we're actually going to put in the regs.
Okay, so let's do this. On 6 6D, we are going to table for the next agenda. And in the interim, in preparation for the next agenda, everybody should have the Code of Federal Regulations that was passed out at the beginning of this and was in your binders. So it should even have a label that says CFRs, and it's on that very first page. And if you go straight down to that lowercase I, you can read that paragraph, but read that in preparation for the next meeting.
Madam Chair, I agree. I just want to digest it a little bit is all I'm saying.
Oh, I agree with that. I don't have a problem with that. Ms. Murray, do you have a comment?
Nova Murray for the record. I don't want to be on the record. Just to make sure we're keeping in mind the criteria of when that is. So if it's willfully underemployed or any other circumstance when we would impute, that we kind of give some guidance on when we impute.
Assemblyman Pickard, can you possibly get your hands on that Supreme Court case and also distribute that to the commission members so we can take a good look at that before the next meeting?
I can do that.
Thank you. And we'll also provide for any of the commission members that aren't familiar with it, the language we do have on imputation of income in Nevada. And we'll start with that so that we're at least ready for the next meeting. Okay. I'm going to close agenda item number 6D, move on to 6E. How are we on time? We're at 2. Well, we're doing good. 6E is discussion and recommendations as to how to develop and adopt an adjustment for additional dependents. It's my personal opinion that this needs to be tabled until we see the initial language from Judge Robb that we're waiting on from 6A, because until we get our initial calculations, I think this is a very difficult conversation to have until we know what we're doing to our baseline calculations.
Makes sense.
Okay. Any disagreement on that, or any discussion anybody wants to have on that? Okay. Moving on to agenda item number 6F. I believe that's the exact same thing. This is regarding adjustment for shared parenting time. We also need 6A before we can move on to 6F and get anything done on that topic. Any
Madam Chair, if I
discussion
may,
against that? Yes.
Ms. Throne, Vice Chair Throne was holding out on us. It's Menier versus Menier is the name of the case, but I will distribute it.
If you could distribute it, I think that'd be easy for everybody, but thank you. Uh, 6F, I'm going to table for the next meeting. I'll move on to 6G, discussion and recommendations as to how to develop and adopt an adjustment for the child's health care expenses. I believe that's also another one that until we get our base calculations, everyone, these are very difficult topics. We put them on the agenda in case we could get to them. We had some early discussions, though, when we had our visitors from all the other states about healthcare expenses. I don't think it's a overreaching, difficult topic for us, but I think until we know what our baseline calculations are, it's difficult for us to discuss any need for changes in it. What the guideline review, I just want to throw out on this one though, what the guideline review is looking for from us is to have it be part of our calculation instead of a deviation. Again, trying to minimize our deviation. So if we keep that in mind as we move through our calculations, that's the goal, is to try to get it on the front end instead of on the back end as a deviation, which shouldn't be difficult to accomplish. So we'll table that. Yes.
Karen Cliff from the Clark County District Attorney's Office. Just to clarify, so, currently the statute regarding if health care expenses are greater than 5% of respondents' gross monthly income, that's taken into consideration. Just to clarify, we still are permitted to address healthcare, or is that separate and apart from what we're discussing?
Good question. I have to find my actual Nevada statute and get there. But let me look at the bill itself. I think it is too. I think we're safe. I think it's actually, well, it's a deviation factor right now, so the mere fact that it's a deviation factor, the deviation factors are within our purview. So if we move it into our calculation and out of the list of deviation factors, it's still within our purview.
Thank you.
And that's your question, right?
Yes, just wanted to confirm.
Okay, yeah. I'm confident
Dawn,
that
can we
it's
clarify
within.
further? I'm sorry.
It's okay, go ahead.
Can we clarify further that when we're talking about healthcare expenses, are we talking about the cost of providing health insurance? That's what we're really talking about, or the unreimbursed medicals? Because I know in district court cases, they deal with those two issues separately.
The cost of health insurance is the actual deviation factor. Where in the statute do we have the unreimbursed medical expense language is the question.
I don't believe that's in the statute.
I don't believe it is either. But if it becomes part of our calculation, did we put it within regulations? Where is the language about that we have to provide within the child support order, how health insurance is going to be dealt with? That came out of 085.
I don't believe that's within the.
That's not within our purview.
278, right?
Mm-mm. Let me look at the statutes again that were repealed.
We did.
Oh, 085's listed in section 13 of the bill of AB 278. So yes, we can.
The cost of health insurance. So Karen Cliff, Clark County District Attorney's Office, when we were discussing, are we talking about unreimbursed medical or the cost of the health insurance? 125B080. It's 9, Section A, the cost of health insurance. Just to clarify.
Yes and no. We deleted out 080 within the actual language of the bill. Yeah, so it's actually crossed out on page 6 and 7 of the bill of AB 278. So it's got to be it's got to be replaced somewhere. We can't just not, because all of our deviation factors are there. We're in trouble if.
Madam Chair,
Yeah.
Just for clarification, the effective date of the repeal is after the adoption. We set it up so that.
Oh, yeah, no, I know.
070
Yeah.
is not adopted until after we adopt our new rules.
Correct. But we'll have a really hard time making any real change if we can't play with the deviation factors or move any of them into our calculations. But within the actual language of the bill, we deleted out the language of 080 and reference the guidelines established through this commission. So even though 080 was not listed in Section 13 as a repealed statute, that statute has been changed to reference any changes we make through this commission.
I suspect that was an oversight as we drafted the final language, and so I think what I would suggest we do, to the extent that there may be an ambiguity there, is we go ahead and move forward, and then in the next legislative cycle, we make that correction if we find an impediment along the way.
I agree. I agree. just the mere language within 080 now points to the guidelines, so to be established. So just because it's not repealed, I mean, it was deleted by AB 278 versus repealed and listed. So I'm going to take the position that it's within our purview, and we'll go from there based on that. Moving on to 6G, let's see. We just did 6G.
Madam Chair, I apologize. Keith Pickard again for the record. If you look
Yeah.
at section 14, sub 2, we're talking about section 2, and we expressly stated that section 2 and all the others become effective on the date of the regulations adopted. So it's clearly within our jurisdiction to do this.
I agree. Thank you. Do we have any other discussion that we want to have on healthcare expenses right now, or prior to me tabling it for the next agenda? Ending 6A. Okay. Is there any data, Ms. Murray just asked if there's any data that we need to gather on the healthcare expenses in order to assist us. I think the question that we're going to be up against is, depending on what kind of methodology we take moving forward on our calculation of child support, will be, are we going to continue the theory of 50-50, or is it going to be adjusted based on the percentage of child support each parent is paying or obligated to, or adjusted based on the circumstances of the parties. So I think however we calculate will have a big impact on that. I don't know that we need any additional data such as the average healthcare expenses or anything like that. Child's healthcare expenses are what they are. Some get hurt, some don't. Some get sick, some don't. Yes, sir.
Keith Pickard for the record. I agree. Something, and I said this very early on, that I'd like to stay away from is designating specific numbers for anything, but let the calculation be exactly that, a formula that then we can deal with these things and give the court some discretion.
Okay, then I'm going to table it for the next agenda. 6H is discussion and recommendations as to how to develop and adopt an adjustment for child care expenses pursuant to item number 13 of Exhibit 44. I'll say that this falls within the exact same discussion we were just having in terms of what we have authority over, what's our purview. It would be a deviation factor that is deleted as a result of 080 being taken out. So I think the same discussion on healthcare expenses applies to this, and that we do have authority over it. I think it's also, again, back to whatever our calculations are going to have an impact on this. Although we had some, and same thing on this discussion, we had some really good input and discussion when we had our visitors telling us about other states and their child support guidelines. I think the most important thing to keep in mind is that I think as a private attorney, there's very much a discrepancy from judge to judge and case to case in the state as to how child care is dealt with, and it is not consistent in my opinion. And it is something, again, that I think is a trigger point for the public to be angry with the system because of it, and that it has to be dealt with specifically, not a deviation factor, but a actual hard calculation on what to do with it, because you either have child care or you don't, and it's an absolutely outrageous expense for nearly every family. So other than that,
Madam
I don't know
Chair.
what to do with it till we know what our calculation is. So yes, sir.
Thank you. I just want to toss in there, though, that when we deal with child care, we're usually dealing with more than just an insurance policy that is going to be somewhat standardized across different insurance companies. Child care is really defined by the parents in many respects, and they come in with different expectations. Some think that Las Vegas Day School is school. Some call it child care, and yet it's very expensive versus the kinder care around the corner might be a quarter of the price. So I, for one, think that child care outside well, I think child care should actually be something outside the calculation. That's my personal opinion.
And Judge Hoskin, just as a comment, I've also had litigants come in and tell me, well, the child is being cared for by my mother, so grandma's caring for the child, and I'm paying her $1,000 a month. And there's standardization from trying to make a determination as whether that's reasonable or not, or whether the money's actually changing hands, puts another wrinkle into it. So I guess the point of my comment was to echo Sullivan Pickard's, was it is going to be a difficult thing to try and narrow down, at least the way that I see it as we sit here today.
Kim Surratt, I think it was, I'm trying to look at my notes, I think it was Minnesota that was, number one, Minnesota was extremely complicated when we listened to that, but there was some really good conversation about childcare. And I agree that it's all over the place, and I agree those excuses are used, but I also would state that there are plenty of judges who either have never had children, or their children, they had them so many years ago that they don't have any reality basis in what childcare costs. And it's... Hey. I didn't say all judges, and I sure as heck don't mean the ones on this commission, right? But it's true. The reality check there is not there, and I think I do know the excuses are there. I agree with it, but I would really like to take a good look at what some of the other states are doing. I do not remember at this very moment what alternatives or samples were given to us in the guideline review over childcare, because I really didn't think this agenda item, we're not actually deep into it because I know we still have to figure out our calculation even. But in tabling this, I want to recommend that we all take a good look at what the review said and what other suggestions were on how to deal with it. The guideline review stated on child care was, let me see, I think it was item 13. 13 goes on the second page. So the review says the child care expenses were identified as reason for deviation. Most states provide a presumptive formula for child care expenses. Providing a formula will reduce the number of deviations and produce more consistent and predictable award amounts. How do we do that? It says review and codify current practices in other states, of course, because that's the answer we get on everything is go to other states. But I don't know what that other state's language is right now. I think she may have given some examples in the review itself, and I will try to come better educated to maybe address this issue in greater detail when we do bring it back up on the agenda. But moving it out of deviation is what her recommendation was, but of course that's the recommendation across the board to us. Any other comments on child care for right now?
Karen Cliff, Clark County District Attorney's Office. I'm happy, since we're sort of looking at some of these Wisconsin guidelines, to provide any statutes regarding child care and how that state handles that issue.
Wonderful, thank you. Take a note on that. Okay, we're going to move on to agenda item number 6I, discussion and recommendations as to how to review and revise the deviation criteria if deemed appropriate. I think that's what we've been discussing anyways. We obviously need to get our calculation down, and then we can figure out what we need to do. Although, for part of the discussion, I would say we have some deviation factors. I'm on completely the wrong page right now, that are, we all know we don't use them. I mean, they're just in the list, and we don't even touch them, and we don't come near them. Although they are some of the balloons that help our judges do what they need to do for these serial parenting, shared parenting scenarios that we don't have clear direction on. So I don't want to get too pin crazy in deleting them, but obviously we need to take a good look at the list of deviation factors that we have. Because once we have a solid calculation and we know what it is going to be under 6A, then we'll know what we need to modify within those deviation factors. Any other comments on that right now? It's a pretty generic category for an agenda item. But
Judge House, can I just ask a question? I know that evidently deviation is a bad word in what we're trying to accomplish here, but isn't there some leeway that we have to maintain some deviation factors for special circumstances?
Yes. I think obviously, so using health insurance as an example again, when we deviate automatically every single time, but we call it a deviation for health insurance, and we could just flip it over onto the other side and make it part of the math calculation on child support instead of saying we'll deviate for it, then we get rid of a huge chunk of our deviations. So the next time we get a review, have a review done on the state of Nevada, our numbers look better and we're more in compliance and we're doing what the feds are requiring of us or asking of us. Plus we get more consistency that maybe on health insurance, maybe there aren't times, you know, there's certain things that we think are important enough to just be part of the calculation. But if we're doing it literally every single time, then there's no reason not to flip it over. But there's no reason to not have deviations. I think part of the reason for this item, recommendation item within the report, is just purely if we make some of the other changes we're talking about making, obviously that deviation list will have to be modified based on some of the other things we're doing. But we all know that at the end, we still need some discretion in our judges to say, but this is a different case. This is a different circumstance, and these people need special attention for them. So, whoever's on the phone talking, we can hear you. Do we have any other comments? Okay. I'm going to close this agenda item and table it for the next agenda. And we are moving on through discuss and approve ideas for future agenda items. We have lots of ones that we tabled today, but are there additional items that aren't on this at all or weren't tabled today that anybody would like to bring to my attention for a future agenda?
I'm not going to state my name for fear that I will have to lead the discussion. However, there are a few things. I did have the opportunity to meet with Ms. Cliff and Mr. Attoon this past week about some of the issues and some of the things that we might want to consider as we're addressing these guidelines. And so I have just a few items that I'd like to suggest we discuss. One of the things was irregular paychecks as they relate to, and this is specific to the 4D program probably, but not necessarily, I suppose, but where a party is working and is paid but receives those paychecks irregularly, there should be some discussion about how that's calculated. We know we're not allowing direct payments to the individuals, but that's something that we probably want to talk about. And then with respect to statute of limitations on arrears, right now Nevada has no statute where other states do. And the idea being essentially the latches argument. If somebody waits 10 years and then brings an action, right now there's no statute of limitations and they can go back for the full amount. We do have a 4-year look back for initial determinations. I believe that's for unmarried parents, but in any event, there's no statute of limitations, and so it creates a problem, particularly as we're dealing with those that are incarcerated. So as we're looking at that, if we do decide to incorporate a statute of limitations, we probably should toll that during a period of incarceration. And then the retroactive support issue actually is outside. That's in 125B030, so that's not within our purview. And then the possibility for gambling intercepts. But anyway, that's outside the scope here as well. But those are just some things that we discussed that we probably want to have as part of the discussion at some point in the future. Thank you.
Anybody else, any additional items? Okay. Going to close agenda item number 7. Move on to number 8 to discuss future meeting dates and our calendar that was sent out through July of 2018. I believe we're going to set that in stone if everybody's okay with that. I don't know. Ryan, do I need a motion on that, or are we?
For future dates of meetings?
Yes.
You really don't.
Okay, I didn't think so. Obviously, if we get closer to dates that we set, for example, in March, and we're getting closer to that date and realizing we need to make modifications to get a quorum, then we'll work on it at that point. But just so everybody has it on their calendar now, I'm hoping that helps a little bit with future planning.
Karen Cliff, Clark
Yes.
County District Attorney's Office. There were 2 dates that I was sort of curious about. One is the week of December 25th. Did I see that right? 29th, so that's the Friday after. I mean, as long as, of course, we have a majority. I wasn't sure how many people accepted their appointments, but just a little curious about that date. But anyways.
I think I will be out of town that week, so that's probably a good point.
Myself included.
Okay, then
I
we
don't
will.
mind having 2 meetings in January.
Yeah, we didn't have another date in December, did we? The 13th. The 13th, December 13th. And then our next one in January was what date? I don't have the dates in front of me, obviously. 17th. We're probably okay with that. A little bit of a stretch there. If we all work real hard at the next meeting. Because I just feel I'm scared to go into 2017 without a little more work done on our base guideline calculations. But between now and our next meeting, we've got some time to accomplish pulling all this data and getting these drafts out to everybody and starting to really dig into it. So would you guys like me to cancel the December 29th date? Is that the consensus?
If I was going to make a suggestion,
Yes.
that just Judge Hoskin, that perhaps we wait until the December 13th meeting to make that call and see how much we get accomplished.
I like that idea. Let's do that. Let's go to our next meeting.
December 29th is penance if we don't do what we're supposed to do on the 13th.
Yes.
I didn't want to say that out loud, but thank you, Judge Robb.
Yes, if the homework is not done. Okay. I like it. That works. We'll wait till our next meeting and we'll look at that December 29th date again. Next agenda item is public comment once again. We'll start with Vegas. It is limited, public comment is limited to 3 minutes total. And as I stated at the beginning, you're also encouraged to submit written public comments to this committee. And if you look at the agenda that was handed out, there's information in that agenda as to how to submit the public comment in writing. But is there anybody in Las Vegas that would like to give public comment at this time? Seeing none.
Yeah, I would like to make a comment if that's okay.
Yeah, are you on the phone, sir? I believe that's.
Yes, this is
Okay.
Michael McDonald.
Okay, Mr. McDonald, it is once again limited to 3 minutes, okay?
Okay.
Okay.
Well, I do want to address some things in regards to child support that you guys might be overlooking. such as I would like you guys to look into the other countries, how they're doing it with a flat set rate. It's causing a lot less litigation, as when you ask for a percentage, it's a lot of fights over children. Another thing I'd ask is maybe you guys can look into doing a card, such as you putting the non-custodial parent or whoever it is that pays child support, putting that income on a card that can be monitored by both parties and is only spent in regards to the children. It would cause a lot less issues with regards to payment for the child and discussions on whether their funds that are being provided are being spent on the children or not. As for the percentages, I would like I said, I would suggest that it would be a national average that set like a set flat rate, and what is based on that, and also lowering that based on parental involvement. Like, as right now, it's all about that percentage of income, how much each parent is making, or in joint custody standards is a set offset. So it'd be nice to have a way to go and what would be best for the kids, whoever has them more in that time, and then lowering it, setting some kind of standard of, hey, I provide this for the children or that, and then that being lowered based on that. Because that would also encourage parental involvement instead of just the paycheck or the deadbeat dad syndrome. So that's been going on. So I would like to address that. And then I would also ask if I could send, I didn't receive an email. I was looking through the paperwork for an email to provide some of the data that we've been collecting. So if I could get that after this, I'd appreciate it. But there's a lot of issues that need to be addressed, and I don't think anybody has the best solution to what is working, what's not. But I would implore the commission to look into the other countries, other states, and see what they're doing. And such as Sweden, countries such as Sweden have gone and done that set rate. It caused 70% of cases never go to trial because there's no incentive to fight over their children. It's also there's no money in it. A lot of people will go and especially with Title 4D, it's a matching program where it provides $1 for every dollar that's collected, thus causing so much litigation and an enforcement piece instead of the involvement. So I would implore you guys to look into the data on that, and maybe I could provide some of that information to you guys as well. If you guys would take the time to look at those studies that we have some groups that put together expert reports on. So, but thank you for your time, and I appreciate you guys looking into this issue.
Thank you very much, Mr. McDonald. Let me ask the staff real quick. Is there an email that he can submit testimony to?
Yes.
Yes. What is the email? Hold on just a second, Mr. McDonald. Don't hang up so we can get it for you, please.
This is Nova Murray for the record. The email address is sxlee@dwss.nv.gov. Do you need me to repeat that?
Yes, could you do the phonetics for it, please?
I'm so good at that. S is in Sam, X is in X-ray, L is in lobby, E as in Edward, at, D as in dog, W as in welfare, S is in Sam, .nv as in Nevada, .gov as in government. Did you get that?
All right, thank you very much, guys. I appreciate it, and I appreciate your time.
Great. Thank you, Mr.
And
McDonald.
looking into this issue, I hope that it can get resolved, and so many people will find out what's best for our children and for our families. Thank you.
We're working on it. Thank you. We appreciate your time. Is there anybody else on the phone that would like to give public comment? Hearing none, is there anybody in Carson City that would like to give public comment at this time? Seeing none, we will close that agenda item, and I will accept a motion for adjournment.
So moved.
Second? All in favor?
Aye.
Aye.
Yes.
Aye. All right. Thank you, everybody. We will see you at the next meeting.
Thank you.